gang violence and other kind of violence.
Get away! I could be at work, at school, in my car, and I can still get shot by the police. Well, I can get shot anywhere.
So it is what it is.
What's good, Shadow Realm? It's your boy Jenquavius Jackson, and y'all already know I'm demonetized and shadow banned in this bitch. So if you want to contribute, go to the Cash App, the PayPal, the GoFundMe, or join the Patreon. Also, don't forget to visit the merch store for all your favorite BGZM News 17 gear, including our exclusive Trump is a Blood t-shirt. Go fast before they sell out. They are already flying off the shelves, no cap. And remember, these super gremlins are on demon time.
Yo, what's good, BGZM News 17 family? I'm at the corner of Jesse Jackson and Marcus Garvey, and I got some bad news for you. As you can see, I lost my job. I'm out here living in cardboard boxes outside of boarded up vacant homes. YouTube said I'm done getting money out here in these streets. They even took my funky ass suit. So anything right now would help. So go ahead and hit that Cash App, hit that PayPal, hit that GoFundMe. Hell, cop the merch. Or if you want to make the long-term commitment to the Jenquavius Jackson Fund, join the Patreon so that I can continue to put out top-notch content each and every day. Also, check out the Rumble, where there is absolutely no censorship. Link in the description box below.
Hey, yo, ain't that nigga Jenquavius? Yo, I recognize.
No, that's not me no more.
Hey, yo, run your
Y'all tell me what they say.
Do the opposite of Antonio Brown and take all
What
your
more
store.
do you want from me?
I have some notes here, and at some points I'll go to them, and at some points I'll.
And listen how sheepish. I mean, it's just so embarrassing. We are the most gullible people of all time. I have some notes here, but I may or may not go to them. All right, preach that, honey, preach that. The crowd in the black churches, Lord. This is why black men have stopped going to church, because all they're going to do is back these black women who, this woman literally had an affair with a married man, and the church, the congregation, preach that, sister. Bro, what happened to women ain't supposed to be preaching in the church? I mean, it's so crazy.
Just going straight from them. But I hope y'all will be patient with me. The bishop told me I am welcome to be myself.
Amen. I'm welcome to be myself. I'm welcome to be ratchet. Translation.
Historic house of God. How many of y'all know that's what Bethel means? House of God. It is literally no place in the world I'd rather be than right here with you today. God always brings you to that safe place where you need to be. And so the invitation.
You hear the buzzwords, the safe place, safe space.
To come where God's message is taught, adhered to, and celebrated is my honor. I want to acknowledge and humbly thank, first of all, my Savior, Lord Jesus Christ.
We ain't gonna do that. Don't bring Christ into this, because you know you are not living Christ-like. And you have black people applauding this debauchery.
But also his humble servant, Bishop Jackson, Supervisor Christy Davis Jackson, Presiding Elder Hudson, Reverend Dr. John Foster, Sister Mary Ann Foster, and Chairperson Carla Morrison told me to invite the seal good.
So she said, no matter what the media is saying about her, no matter the fact that she had an affair with a married man, no matter the fact that she is defrauding this whole congregation, as a matter of fact, because these are Fulton County taxpaying people, no matter that she has defrauded the city of Atlanta, she's still welcome to come to the black church, honey. Yes. And preach the truth in a safe space for black women. In Jesus' name. It's absolutely ridiculous.
I hope for y'all this week, I don't look like what I've been through. I want y'all to know I pulled out
What I've been through? You mean what you put yourself through?
my most lavish $29.99 dress from Ross.
So she trying to act like she broke. I pulled out my most. She's trying to appeal to the black community. She's insulting our intelligence and our pockets. Well, how are y'all not seeing this? I pulled out my best $29.99 dress from Ross. I know everybody in this congregation can afford that. Can I get an amen? Amen. God damn it. We're just... It's a lot of fun.
I stand to talk to you this morning. See, that part's funny. That's not going. Now, I must warn you, you are looking today, this morning, to hear from a perfect person. Well, he was crucified and he died for your sins.
So there you go. Now, to absolve herself from accountability, I'm not Christ and I'm not perfect. I am not Jesus Christ. If you're looking for a perfect person, he died 2,000 years ago. I mean, it's just fucking ridiculous, man. We fall for the same trap every single time. And not one black man or woman said it from the crowd, hey, didn't you fuck that special prosecutor that you hired to prosecute Trump? Damn. No dissent in this congregation. No questioning. And she's trying to act like she is preaching the word of God. Yeah, Miss Berry makes a great point. She's gathering that jury. Yes, because in Fulton County, that jury is going to be a black jury. You best believe it. And she's trying to get these people on her side so that she still has a case against President Trump. It's not going to work.
But today, what he has brought you is his very flawed, hard-headed, and imperfect servant.
Servant of who? Satan? Very flawed, hard-headed. Doesn't God tell you not to harden your heart? Right? I mean, it doesn't sound like she's working for God.
And so I pray for him to please use me this morning. Some people are in this place to hear the word of God. Others are here for other reasons, but my God got a way of making sure no matter why you came, you leave with his message. So the theme being celebrated today is, it starts with me. I want somebody to repeat that. It starts with me. Shifting the cultural climate through the study and...
Yeah, she should have never became a district attorney. She should have just went into the black church. She could have made plenty of money without the eye of scrutiny, a whole bunch of gullible people inundated by, you know, Christian morals that she isn't even upholding herself. And she would have been able to skate free. She would have been able to do whatever she wants. Tax-free, building, all that shit. She could have embezzled the tithes and offerings, whatever she want to do. Use that money to pay the deacons who fucking her. Anything. But instead, she becomes an elected official who is supposed to represent law and order in our state, in our city. And this is what we get.
Practice of Dr. King's non-violent philosophy. So I'm going to start here. When I researched the history of this monumental church, 2 words just jumped off the page at me. And the words were this: this church is built on faith and resilience. The hard-headed, flawed, imperfect servant before you is built and is being constantly chiseled on faith and resilience. I smiled when I read the description.
You hear that, nigga? That's it. That's it. That's it. Lord.
I knew God was telling me, I'm sending you where you need to be. I was invited here to give you a message, but yet my God does what he always does. He brought a message to me. He knew this child needed reminding. So I want to talk to you today about what it's required to be a soldier in this warfare. And that's what it is. Warfare to shift the cultural climate. I must reveal to you a secret though. Oh, wait for it, they want to know.
What's the secret? Are you going to tell us that you were getting papped out by Nathan Wade?
The journey is ugly. The journey is painful. The journey is full of pitfalls.
It sounds like the journey was pleasurable.
But if you are one of his children, you must answer the purpose. You must answer the call. Y'all don't hear me. You must answer the mandate. The question becomes, are you qualified? And it really comes down to this.
I know she did not ask, are you qualified? Are you qualified? Was Nathan Wade qualified? How are Black people falling for this? It's so disappointing. The preacher at this church should not have allowed her to come unless she was going to come and admit her sins. This is the part where you go into the little booth and you admit your sins to the priest, and then you come to the altar call so that people can pray for you, lay hands on you, let you know that you have done wrong, but that we are still going to, you know, be there for you because you're a sister in Christ. But instead, she doubles down, says she hasn't done anything wrong.
How much are you personally willing to sacrifice for the greater good and his purpose? How much? I want you to really sit and think about that question. How much are you willing to sacrifice for God's purpose? See, I must confess to you, as a little girl, I really did not think that Dr. Martin Luther King's dream would still be just a work in progress.
Oh my God.
2024.
So Dr. Martin Luther King's dream is still a work in progress, but when we saw who was trying to burn down Dr. King's historic home in Atlanta, who was it? Who was it? It was a Black woman, y'all. She took gasoline. She poured it on Dr. King's home that was in the process of being remodeled in the city of Atlanta. She took a match, a lighter, and had to be tackled by good Samaritans, a couple who were white men, to save Dr. King's home.
What's good, Shadow Realm? It's your boy Jenquavius Jackson, and y'all already know I'm demonetized and shadow banned in this bitch. So if you want to contribute, go to the Cash App, the PayPal, the GoFundMe, or join the Patreon. Also, don't forget to visit the merch store for all your favorite BGZM News 17 gear, including our exclusive Trump is a Blood t-shirt. Go fast before they sell out. They are already flying off the shelves, no cap. And remember, these super gremlins are on demon time.
Gang violence and other kind of violence.
Guess what? I could be at work, at school, in my car, and I can still get shot by the police. But I can get shot anywhere.
So it is what it is.
What's good, Shadow Realm? It's a Black Gen Z mindset. Make sure you go ahead and like, comment, share, subscribe, and let's get into the video. All right, guys. So I want to break this down. This is a very important story. It's wild that we even have to cover this, but unfortunately, Fanni Willis was not disqualified from trying the election interference case against President Trump. And she is being, she's been enabled to continue the case in a split Solomon judgment, or Solomon ruling is what they're calling it. But I don't think it's a Solomon ruling. But It is a split judgment by Judge Scott McAfee, a very partisan judgment, in my opinion. He put political party, he put his own political aspirations into account, into thought when making this ruling, because he's up for re-election in the next couple of weeks and he wants to essentially keep his job. So in order to appease the black women of Fulton County, he makes this ruling to keep Fanni Willis on the ballot. But he does kind of smear her in his 23-page written ruling that we will go through, and we're going to read every page and determine if we think it's a just ruling or not, which obviously it's not. But it's so crazy that he would not disqualify her, especially when reading the ruling, because it's obvious that he believes that Nathan Wade lied on the stand. It's obvious that he believes that, but he's saying that it's not conclusive that Fanni Willis lied on the stand, but they were telling the same freaking story. So how did they both not lie on the stand if they're telling the same exact story? So this is what I'm talking about when I'm just speaking upon just the unfairness, right? This is not right. It's obvious there was a conflict of interest. She's smashing the prosecutor that she hired to take this case on. I mean, it's an ethical dilemma. There's so many issues with this, but forget it. We're just gonna go into it. I'm gonna look at a couple news stories real quick. Then we're gonna read his ruling. I think he got it wrong. I really think he got it wrong, and it's unfortunate that he did get it wrong, because this makes people lose faith in the justice system. Okay, especially in a time where we need more faith than ever in our justice system. So let's watch.
That is the judge's ruling over whether Fulton County DA Fanni Willis should be allowed to continue her prosecution of former President Donald Trump and his allies. Good evening, and thank you for joining us for Fox 5 News at 5. I'm Russ Spencer.
I'm Courtney Bryant. Defense attorneys wanted Willis and her office removed from the case and the entire indictment dismissed because they argued the DA's romantic relationship with a subordinate created a conflict of interest. Fox 5 team reporter Randy Travis says the judge criticized her judgment but found the defense did not prove its case. Randy.
That's right, Courtney and Russ. Judge McAfee's order, in essence, says Willis can stay if her ex-boyfriend Nathan Wade resigns from the case. Well, this afternoon, the special prosecutor hired by Willis to oversee the investigation did exactly that. Willis must now find a replacement, while at the same time work to repair her reputation.
You're confused. You think I'm on trial. These people are on trial for trying to steal an election in 2020.
That trial is now back on track, following a judge's ruling that allows Fanni Willis in charge of the election interference case. In his 23-page ruling, Judge Scott McAfee decided the evidence did not establish the district attorney's receipt of a material financial benefit as a result of her decision to hire and engage in a romantic relationship with Wade. Defense attorneys for 9 of the 15 remaining defendants argued Nathan Wade was hired primarily because he was dating Willis.
And that's literally why he was hired, because she was having trouble even finding a prosecutor to take this case on, because it's a nothing burger. There is no case. President Trump didn't do anything wrong when he did challenge the results of the election, which he is, he has a right to challenge the results of the election. And we all know that it was there was a lot of funny business going on with these mail-in ballots, with people stuffing the ballots, all this stuff. So it's crazy.
And the two vacationed together with Wade, spending what the court determined was as much as $15,000 on his boss. But the couple, who say they only started dating after he was hired and also broke up shortly before last August's indictment, testified Willis paid or reimbursed Wade for roughly half of those expenses, and all in cash.
You don't have a single solitary deposit slip to corroborate or support any of your allegations that you were paid by Mrs. Willis in cash, do you?
No, sir.
Not a single solitary one. Not a one.
That seemed to satisfy the judge. Simply put, the defendants have not presented sufficient evidence indicating that the expenses were not roughly divided evenly. McAfee did agree the relationship was, quote, a tremendous lapse in judgment, but he refused to disqualify Willis from the case.
Right.
Instead, giving her this option. The district attorney may choose to step aside, along with the whole of her office, and refer the prosecution to the prosecuting attorney's counsel for reassignment. Alternatively, Special Prosecutor Wade can withdraw, allowing the district attorney, the defendants, and the public to move forward without his presence or remuneration distracting from and potentially compromising the merits of this case.
But the merits of the case have already been compromised, because if Nathan Wade is wrong, the prosecutor, then Fanni Willis is wrong for hiring him when they're having sex. It just doesn't make sense why he made this ruling, but it does, because he's a Democrat judge and he's saving one of his own. He voted for Fanni Willis. He donated to her campaign. He supports her. And he really didn't even want to have this hearing come up, but his hand was forced because there was an appearance of impropriety. And there's a lot of evidence that suggests that their relationship started before they said it did. And a lot of evidence that they perjured themselves. It's 100% without a doubt that Nathan Wade perjured himself. And I believe it's 100% without a doubt Fanni Willis perjured herself as well. But the judge's opinion, he thinks that there's only, a chance that Nathan Wade perjured himself. And obviously we know that the testimony from, what's his name? Bradley. I forgot his first name. But his testimony was unreliable, even though he's the reason why this hearing had to even be brought forward, because he was running his mouth like a chatty patty. So it's crazy.
They ain't just giving this to black men.
The judge also wrote that this fiery speech by Willis accusing her critics of racism created dangerous waters for the DA and was legally improper. But McAfee ruled it did not cross the line to deny defendants a fair trial. As we mentioned, Nathan Wade has resigned effective immediately. In his letter to Willis, he wrote, "Seeking justice for the people of Georgia and the United States and being part of the effort to ensure that the rule of law and democracy are preserved has been the honor of a lifetime." In her response, Willis wrote, in part, "I will always remember that you were brave enough to step forward and take on the investigation. Others who were considered were understandably concerned for the safety of themselves and their families that would arise from their acceptance of your role. You were the one who had the courage to accept the role, even though you did not seek it." And again, that resignation is effective immediately.
You talked about Fanni Willis's need to repair her reputation. The words that stuck out to me was when the judge said there's an odor of mendacity surrounding how they testified about their relationship. That's as close as you can come to calling somebody a liar without calling them a liar.
Yeah, mendacity, a tendency to lie is the definition. Yeah, that's certainly it was a mixed bag here, I guess you could call it, for Fanni Willis. She gets to stay on the case, but her reputation took a big hit.
Yeah, and it sounds like this is only the beginning. There could be other investigations as well as this after this one has wrapped up.
And we still don't know if any of the 9 defense attorneys will file an appeal in this case, which would continue to slow it down. It all depends now on Judge McAfee. If an appeal is requested, whether he grants one.
Randy, thanks very much.
All right, thanks, Randy.
So you hear that they can appeal this ruling and this decision, but honestly, I think it would be best if Fanni Willis just leave it alone. If she's going to continue the case, which I think she should recuse herself, but I don't think she is, because she has too much pride and she's a strong, independent black woman. So if she does go ahead and continue the case, it might be best if she just leaves that ruling alone and doesn't try to appeal it, because if they subpoena the actual text messages, it's going to be 100% proven that she perjured herself.
The eyes of the nation have been fixated on Fulton County for some time. This ruling is no different.
Our team coverage continues now with Fox Eye's Eric Perry. Eric, you've been outside the Fulton County Courthouse all day getting reaction from both sides.
Yeah, Russ, Courtney, happy Friday to both of you. I've spent the day reaching out to all sides of this case. We have yet to hear back from the Fulton County District Attorney herself or her office. We did get our hands on that resignation letter from Nathan Wade. On the other side, the defense attorneys for the defendants in this case, they all tell me they are weighing their options moving forward.
I don't think it came as a shock. Judge McAfee has shown a tendency to want to hold a middle ground and not show favoritism to either side.
Visiting associate professor with Emory Law, John Acevedo, breaks down potential reactions from both sides after Fulton County Superior Court Judge Scott McAfee handed down a decision on if District Attorney Fanni Willis should be removed from the Georgia election interference case. The judge ruled either Willis and her team must go or special prosecutor Nathan Wade.
He didn't give a full win to either side. Since the beginning, he'd also been worried about the appearance of a conflict of interest as much as actual conflict.
I asked what could be happening behind the closed doors in Willis's office.
I think they're having a very hard conversation with Nathan Wade as to why he's stepping down as special prosecutor, because given the options of her and her entire office removing themselves from the case or him removing himself from the case, he's easier to replace than her.
As for the defense, Acevedo says they are figuring out the next steps, which could mean filing an appeal.
This is a prime opportunity to have the case completely ended and a very low cost to them, the filing of a paperwork and a brief of appeal. So low cost, high reward.
I reached out to many of the defense attorneys, and here's how they are responding. Ashley Merchant, who initially discovered the romantic relationship and represents defendant Mike Roman, sent a statement saying, in part, the judge clearly agreed with the defense that the actions of Willis are a result of her poor judgment and that there is a risk to the future of this case if she doesn't quickly work to cure her conflict. Steve Sadow, who represents arguably the biggest name in the case, former President Donald Trump, sent a statement saying, in part, while respecting the court's decision, we believe that the court did not afford appropriate significance to the prosecutorial misconduct of Willis and Wade. Yeah, back out here live, Courtney, Russ. Two other things we have to talk about: a jury and time. Again, this is going to be on the minds when they go to pick potential jurors for this case here, especially with how big in the media and the hearings were so public there, to make sure there's no prejudice, not just for the defendants in this case, but now against the prosecution and the district attorney. And all of this, picking a new special prosecutor, what they're going to do moving forward, just kicks it down the line a little bit further for a start date to this trial. Outside the Fulton County Courthouse, Samir Perry, Fox 5 News.
Oh, man. So they're going to end up putting this case in the hands of a Fulton County jury, which we all know is going to be stacked to the left, unfortunately. So the hands or the fate of the country are in the hands of the people of Fulton County, basically the community. So, I mean, in my opinion, I know people are saying this is a good, or it's a good thing that something happened and all this kind of stuff. I don't like the ruling. I think it's a sign that they can rig anything. And you know, it just helps it, or it loses my faith in the justice system as we know it, especially in the state of Georgia, in particularly Fulton County. But hey, let's hear what the judge had to say. Let's read the ruling state. And this is his basically his ruling for the disqualification hearing in the Superior Court of Fulton County, state of Georgia, versus Donald Trump, Rudolph Williams, Louis Giuliani, Mark Randall Meadows, Jeffrey Bozier Clark, Robert David Cheeley, Michael A. Roman, David James Schaefer, Harrison William Prescott Floyd, and Kathleen Alston Latham. So, order on defendants' motions to dismiss and disqualify the Fulton County District Attorney. All right. So, on January 8, 2024, defendant Roman filed a motion to dismiss the indictment and disqualify the Fulton County District Attorney's office. 8 co-defendants later joined and supplemented the motion, raising additional grounds for disqualification. Among other allegations of disqualifying conduct, the defendants contend that the district attorney obtained a personal stake in the prosecution of this case by financially benefiting from her romantic relationship with Special Assistant District Attorney Nathan Wade, whom she personally hired to lead the state's prosecution team. More specifically, defendant Roman alleges that the district attorney and SADA, which is a Special Assistant District Attorney Nathan Wade, traveled together on multiple vacations, with Wade covering many of the associated expenses. Defendant Roman later supplemented his motion with receipts from some of these travels. The state responded with an affidavit arguing that the district attorney had not received any financial benefit through her relationship with Wade, and their personal travel expenses were roughly divided equally. The state's opinion, Roman document 65, Exhibit A. So they're just referencing exhibits here. As alleged, the claims presented a possible financial conflict of interest for the district attorney. More importantly, the defense motions and the state's response created a conflict in the evidence that could only be resolved through an evidentiary hearing, and one that could not simply be ignored without endangering a criminally accused constitutional right to procedural due process. After receiving 2.5 days of testimony, during which the defendants were provided an opportunity to subpoena and introduce whatever relevant and material evidence they could muster, the court finds that the defendants failed to meet their burden of proving that the district attorney acquired an actual conflict of interest in this case through her personal relationship and recurring travels with her lead prosecutor. So that finding by the court, aka the judge, is a huge deal. That is a huge deal. So after receiving 2.5 days of testimony, in which, let's go back over the testimonies, we had one witness who was, I forgot her name, but Fanni Willis's former friend said 100% that their relationship started in 2019. In the summer of 2019, after a Zoom meeting where Fanni Willis and Nathan Wade met, and that Zoom meeting was subpoenaed by the defense's attorney, the white lady with the blonde hair. I think her name's Ashley something, I forgot. But it's a big deal that after the testimony of Bradley, Wade, Willis, and the friend, they find that they couldn't meet a burden of proof that Fanni Willis had a conflict of interest. How is that possible when we have phone records of their location, thousands of text messages that the context of those text messages have not been released because they didn't subpoena those, but the fact that they were texting that many times, showing up at wee hours of the night, leaving it at wee hours in the morning. I mean, everything's there. They already admitted that they were smashing currently, and the relationship had recently just dissolved, probably because they got caught. And there's even potential that Fanni Willis lied about the relationship in a divorce hearing, okay, between Nathan Wade and his former wife. So there's just so many things going on here, and the court is saying that they couldn't, or the defendants didn't prove it. The other alleged grounds for disqualification, including forensic misconduct, are also denied. However, the established record now highlights a significant appearance of impropriety that infects the current structure of the prosecution team, an appearance that must be removed through the state's selection of one of two options. The defendant's motions are therefore granted in part. Actual conflict of interest. Our highest courts consistently remind us that the prosecutors are held to a unique and exacting professional standard in light of their public responsibility and their power. Every newly minted prosecutor should be instilled with the notion that she seeks justice over convictions and that she may strike hard blows but never foul ones. See Berger versus United States. Most importantly, prosecutors are expected to assume a role beyond a mere advocate for one side and must make decisions in the public's interest, not their own personal or political interest, which obviously she is persecuting or prosecuting President Trump for political gain. Recognizing these are not empty slogans nor toothless admonitions without practical effect, Georgia courts have not hesitated to step in and use their inherent authority to disqualify a state prosecutor when required, especially when the prosecutor labors under an actual conflict of interest. Let's keep going. They're just citing some legal precedent here. Sorry, let me just find when they start. Everything according to the term. When conducted. Okay, disqualification of a prosecutor due to a conflict of interest is thus not a creature of statute so much as it is a judicial remedy recognized by our appellate courts since their formation, generally on grounds of public policy, as the administration of the law should be free from all temptation and suspicion so far as human agency is capable of accomplishing that object. So this is just more legal precedent here. Just want to make sure I'm not skipping any pertinent information. If you want to look up these cases too, that's by all means, you can do that, but I don't have time. The Georgia Supreme Court has most recently denoted conflicts of interest and forensic misconduct as the two generally recognized grounds for disqualification. A conflict of interest includes acquiring a personal interest or stake in the defendant's conviction, which we know she is definitely going to see a boost in her career. Maybe even governorship in the future, Senate, a senator in the future. Who knows? But I mean, honestly, if Fanni Willis isn't stopped now, she could in a few years, not a few years, but in a couple decades, maybe she could even find her way to the Supreme Court after getting a conviction of former President Donald Trump. So that's how high the stakes are for her in this case. And that's where the conflict of interest is. That's where the potential future for employment and financial gain comes into play. And it's like the judge is being so naive and short-sighted in what I believe to be a political decision that he wouldn't rule that there is a conflict. This is so because the prosecutor's duty to the public creates an additional public interest that must remain unconflicted in every criminal case. A determination of whether a prosecutor is laboring under a conflict of interest is a fact-driven one. Okay, so let's keep going. In this case, SADA Wade's manner of payment is not actionable on its own. Whenever a private attorney like Wade is paid by the billable hour, a motive exists to extend or prolong the assignment. This, however, is a tension that the legal profession has long accepted. It is also the type of speculative status violation that our courts have regularly denied as insufficient grounds for disqualification absent solid proof of some other conduct. So they're basically saying there was no action that Nathan Wade took to try and prolong the case because, obviously he's being paid by the hour, and legal precedent has basically been set that most legal professionals kind of accept that, yes, some cases may be prolonged, but it's not due to the fact that they're trying to prolong it, or maybe, in some cases it potentially could be, but the prolonging of the case is ultimately in order to seek some type of justice. I know it's a little confusing, but I'm just trying to summarize it as best I can. Thus, a SADA's oath of office in combination with the supervision theoretically provided by a neutral and detached district attorney should generally be sufficient to dispel the appearance of the improper incentive. Nor would a romantic relationship between prosecutors standing alone typically implicate disqualification, assuming neither prosecutor had the ability to pay the other as long as the relationship persisted. But in combination, as is alleged here, by the defendants, prima facie argument arises of financial enrichment and improper motivations, which inevitably and unsurprisingly invites a motion such as this. As to the financial allegations, the court makes the following factual findings. On November 1st, 2021, the district attorney hired Nathan Wade to serve as SADA and lead the investigation that produced the indictment in this case. The district attorney considered at least one other option before hiring Wade, extending an offer to former Governor Roy Barnes, who declined. Now, why did former Governor Roy Barnes decline? Most likely there was no case. The contract allowed a $250 hourly rate, a relatively low amount by Metro Atlanta standards for an attorney with Wade's year of service, and contained a ceiling on the maximum number of hours permitted. Under the terms of the first contract, Wade was not to perform more than 60 hours of work per month without written permission. No evidence introduced indicates that Wade ever received permission to exceed these monthly hourly caps. His contract was renewed on November 15, 2022, and again on June 12, 2023. Between October 22nd and May 2023, the district attorney and Wade traveled together on 4 occasions that resulted in documentable expenses. The first included an extended trip in October 2022 to Miami and Aruba and a cruise. Wade initially covered expenses for the October 2022 trip totaling approximately $5,223. In December 2022, the two flew to Miami for another cruise, for which the district attorney paid $1,394 for plane tickets, while Wade purchased passage for the cruise along with other vacation-related expenses totaling approximately $3,684. In March 2023, the two traveled to Belize, where Wade covered resort and restaurant expenses in the amount of approximately $3,000. Excuse me. All right. Gotta take a sip. All right. Approximately $3,000. All right. Let's keep going. In May 2023, they traveled to Napa Valley, where Wade covered airfare, lodging, and Uber rides in the amount of around $2,829. In addition, the two described taking a number of day-long trips to Tennessee, Alabama, South Carolina, North Carolina, and other parts of Georgia. They also admitted to dining out on multiple occasions and taking turns covering the bill, with seemingly full access to Wade's primary credit card statements. The defendants did not produce evidence of any further documentable expenses or gifts, nor were any revealed through the testimony. In total, defendants point to an aggregate documented benefit of at most approximately $12,000 to $15,000 in the district attorney's favor. The district attorney and Wade testified that these expenditures were not meant as gifts and not designed to benefit the district attorney. Both testified that the district attorney regularly reimbursed Wade in cash, and if not reimbursed, the district attorney covered a comparable related expense. For example, the district attorney testified that she reimbursed Wade in cash for the Aruba trip, which she estimated cost around $2,000, and that she gave him money. For both cruises, okay, she further claimed that she reimbursed Wade for the entirety of the Belize trip and that she paid for the Napa Valley excursions. Finally, while Wade could have bought meals in 2020, which totaled more than $100, she would also regularly pay for his meals. Such a reimbursement practice may be unusual, and the lack of any documentary corroboration understandably concerning. Right. And this is the judge writing this. Yet the testimony withstood direct contradiction, was corroborated by other evidence. For example, her payout of airfare for two on the 2022 Miami trip, and was not so incredible as to be inherently unbelievable. So how is it not unbelievable that she didn't pay any of this money back? I think that, he was paying for the trips. She never paid him back. And, he was tricking on the DA, trying to impress her, trying to keep his job, whatever. However, as the district attorney herself acknowledged, no ledger exists other than a best guesstimate. There is no way to be certain that expenses were split completely evenly, and the district attorney may well have received a net benefit of several $100s. Despite this, after considering all the surrounding circumstances, the court finds that the evidence did not establish The district attorney's receipt of material financial benefit as a result of her decision to hire and engage in a romantic relationship with Wade. Simply put, the defendants have not presented sufficient evidence indicating that the expenses were not roughly divided evenly, or that the district attorney was or currently remains greatly in pecuniary interested in this prosecution. Wow. So that is a big blow to the Trump defense, where they're basically saying that there's no way for you to prove that Fanni Willis didn't pay it back, since she's claiming that she paid them back in cash. In addition, and much more important, the court finds, based largely on the district attorney's testimony, that the evidence demonstrated that the financial gain flowing from her relationship with Wade was not a motivating factor on the part of the district attorney to indict and prosecute this case. While a general motive for more income can never be disregarded entirely, the district attorney was not financially destitute throughout this time or in any great need, as she testified that her salary exceeds $200,000 per year without any indication of excessive expenses or debts. Similarly, the court further finds that the defendants have failed to demonstrate that the district attorney's conduct has impacted or influenced the case of the defendant's detriment. While prejudice is not a required element for disqualification, it is relevant to considerations of due process and the defendant's requested remedy for complete dismissal. Defendants argue that the financial arrangement created an incentive to prolong the case, but in fact, there is no indication the district attorney is interested in delaying anything. Indeed, the record is quite to the contrary. Before the relationship came to light, the state requested that the trial begin less than 6 months after indictment. Soon thereafter, the state opposed severance of the objecting defendants, who did not demand their statutory right to a speedy trial. So essentially, the argument was that they were paying Nathan Wade, and he was padding his pockets by prolonging the case. And this is the argument the defense gave. But the reality is the state wants to speed the case up because they want Trump to be convicted before the election, so people go out and vote against him because he's a convicted whatever they're going to convict him with, right? Because he's convicted of a crime. So they want to go ahead and get that conviction before the election to interfere with the election and essentially influence the decision of the people, so that they can get the conviction. And then if Trump appeals it and wins on appeal, it doesn't matter because he already lost the election. So the state argued that it only wanted to try the case once, assuming that such a trial would have been affirmed after any necessary post-conviction appeals. The state amended its proposed timeline in November 2023 to request that the trial commence less than 1 year after the return of the indictment. And even before indictment, the district attorney approved a grand jury presentment that included fewer defendants from the special purpose grand jury recommended. See order here. Boom. In sum, the district attorney has not in any way acted in conformance with the theory that she arranged a financial scheme to enrich herself or endear herself to Wade by extending the duration of this prosecution or engaging in excessive litigation. Even bringing this case forward is excessive litigation, but oh well. Without sufficient evidence that the district attorney acquired a personal stake in the prosecution or that her financial arrangements had any impact on the case, the defendant's claims of an actual conflict must be denied. This finding is by no means an indication that the court condones this tremendous lapse in judgment or the unprofessional manner of the district attorney. So this is where he kind of breaks her down here, of the district attorney's testimony during the evidentiary hearing. Rather, it is the undersigned opinion that Georgia law does not permit the finding of an actual conflict for simply making bad choices, even repeatedly. And it is the trial court's duty to confine itself to the relevant issues and applicable law properly brought before it. Other forums or sources of authority, such as the General Assembly, the Georgia State Ethics Commission, the State Bar of Georgia, the Fulton County Board of Commissioners, or the voters of Fulton County, may offer feedback on any unanswered questions that linger, but those are not the issues determinative to the defendant's motions alleging an actual conflict. But she did perjure herself, which she should be removed and disbarred for that. But, you know, it's all BS. Appearance of impropriety. Finding insufficient evidence of an actual conflict of interest does not end the inquiry. Our appellate courts have endorsed the application of an appearance of impropriety standard to state prosecutors, even without any explicit finding of an actual conflict. All right, let's keep going. They're just citing case law. The cases cited here that resulted in disqualification did not hold that an actual conflict is a necessary prerequisite. The state nevertheless argues that the facts presented suggest as much, and while that may be so in some instances, the opinions do not make the findings of this court, and this court cannot ignore the explicit language of the Georgia Supreme Court and multiple opinions from the Georgia Court of Appeals. Further, while Davenport in the first instance, this court can find where the exact phrase appearance of impropriety is used to assess the disqualification of a state prosecutor that references to Caesar's wife in Nicholas versus State, and the admonition against all temptation and suspicion in Golden versus State demonstrate the principle has long been endorsed in Georgia law. While formally undefined in Georgia precedent, an appearance of impropriety is generally considered conduct or status that would lead a reasonable person to think that the actor is behaving or will be inclined to behave inappropriately or wrongfully. And here's the worst. Here's the worst thing about this. This ruling sets precedent in the future. So if we have a scenario like this again, where you have a district attorney who is smashing a prosecutor in the court in Georgia courts, especially Fulton County, this ruling can serve as precedent to say, hey, there was no appearance of impropriety or conflict of interest rather found in this case. So, whatever case it be in the future should have the same ruling as far as getting rid of or disqualifying a district attorney, a rogue district attorney, that is, from prosecuting a defendant. Borrowing from federal judicial recusal standards, a reasonable person is not an uninformed member of the public with only a passing knowledge of the facts at hand. This must be the standard, as otherwise, in this case, a casual, uninformed, or misinformed observer might believe the district attorney must recuse herself merely because her father shares a last name with a co-defendant. Nor is a reasonable person hypersensitive or unduly suspicious without an understanding of the relevant legal standard in judicial practice. I mean, I guess that has something to do with the previous case law, but I mean, I don't see how that's relevant. The appearance standard recognizes that even when no actual conflict exists, a perceived conflict in the reasonable eyes of the public threatens confidence in the legal system itself. When this danger goes uncorrected, it undermines the legitimacy and moral force of our already weakest branch of government. I just don't understand why he keeps saying there was no conflict. There was a conflict. She's literally benefiting financially from smashing the prosecutor, and she was smashing him before she even hired him. That's a direct conflict of interest. It's crazy. Thus, it is that sometimes an attorney, guiltless in any actual sense, nevertheless, is required to stand aside for the sake of public confidence in the probity of the administration of justice. This court finds that it can and indeed must consider the appearance of impropriety as a basis for a state prosecutor's disqualification, especially in recognition of the critical role that the prosecutor plays in the criminal justice system. One final observation can be gleaned from a careful study of our appellate decision applying the standard. The remedy can vary. Unlike an actual conflict, the finding of an appearance of impropriety does not automatically demand disqualification. Our Supreme Court has previously analyzed disqualification under an appearance standard in a civil case using a continuum, recognizing that disqualification is not always the appropriate outcome. Let's see. At one end of the scale, where disqualification is always justified and indeed mandated, even when balanced against a client's right to an attorney of choice, is the appearance of impropriety coupled with a conflict of interest or jeopardy to a client's confidences. In these instances, it is clear that the disqualification is necessary for the protection of the client. Somewhere in the middle of the continuum is the appearance of impropriety based on conduct on the part of the attorney. As discussed above, this generally has been found insufficient to outweigh the client's interest in counsel of choice. This is probably so because absent danger in the client, the nubilis interest of the public at large in the propriety of the bar is not weighty enough to justify disqualification. Finally, at the opposite end of the continuum is the appearance of impropriety based not on conduct but on status alone. This is an insufficient ground for disqualification. Let's see. Okay, they're still citing case law. Let's see where I can jump in. Similarly, in Billings versus State of Georgia, although the Court of Appeals found the existence of appearance of impropriety, it noted that the appearance could be cured through screening the affected prosecutor from participation or discussion of the affected case. These cases indicate that a trial court can consider alternative solutions to cure the appearance of impropriety. Nor would the findings of an appearance of impropriety on the part of the district attorney herself, in contrast to an actual conflict, necessarily result in the disqualification of the entire Fulton County District Attorney's Office. The district attorney in McLaughlin was absolutely disqualified due to personal interest in the prosecution. McLaughlin versus Payne. As a result, assistant district attorney appointed by the district attorney lacked any authority to proceed. McLaughlin did not address an appearance standard and made a point to limit the total disqualification of instances of absolute disqualification when the appearance of a conflict exists. Only the affected prosecutor, be they elected or appointed, is affected. So that's the head prosecutor. The individual prosecutor who has a conflict based on at least the appearance of impropriety may be disqualified from participation in the case, but not all the other prosecutors who work for or who work with him. So that's why he gave that split decision. So he looked deep into case law to try and justify his decision. With these principles in mind, and they could even be potentially found to have witness tampered with Terrence Bradley, because it's like this guy was spilling the beans. It was like he had it out for Nathan Wade beforehand, but then once the hearing started, he is quiet as a church mouse. So, it's just very interested. It's very interesting to see the ruling that he ended up making. Whew. All right, almost done. With these principles in mind, the court finds that the record made at the evidentiary hearing established that the district attorney's prosecution is encumbered by an appearance of impropriety. This appearance is not created by mere status alone, but comes because of specific conduct and impacts more than a mere nebulous public interest, because it concerns a public prosecutor. Even if the romantic relationship began after SADA Wade's initial contract in November 2021, the district attorney chose to continue supervising and paying Wade while maintaining such a relationship right. She further allowed the regular and loose exchange of money between them without any exact or verifiable measure of reconciliation. This lack of confirmed financial split creates the possibility and appearance that the district attorney benefited, albeit not materially, from a contract whose award lay solely within her purview in policing. So that's literally the conflict right there. And he's saying, oh, well, it's an appearance of impropriety, but it's not a direct conflict of interest. This is fucking crazy. It's a joke. Most importantly, were the case allowed to proceed unchanged, the prima facie or facie, concerns raised by the defendants would persist. As the district attorney testified, her relationship with Wade has only cemented after these motions and is stronger than ever. Wade's patently unpersuasive explanation for the inaccurate interrogatories he submitted in his pending divorce indicates a willingness on his part to wrongly conceal his relationship with the district attorney. So he filed false documents in his divorce case. As the case moves forward, reasonable members of the public could easily be left to wonder whether the financial exchanges have continued, resulting in some form of benefit to the district attorney, or even whether the romantic relationship has resumed. Put differently, an outsider could reasonably think that the district attorney is not exercising her independent professional judgment totally free of any compromising influences. As long as Wade remains on the case, this unnecessary perception will persist. And the perception is going to continue to persist whether Wade is on the case, because Fanni Willis is on the case because she engaged in this behavior with him. So I genuinely don't see how she's not thrown out as well. The testimony introduced, including that of District Attorney Wade, or District Attorney and Wade, did not put these concerns to rest. During arguments, the defendant's focus largely pivoted from the financial concerns to disproving the testimony of the district attorney, namely that her romantic relationship actually predated the November 2021 hearing, a hiring of Wade. On that front, the court makes a few brief observations. First, the court finds itself unable to place any stock in the testimony of Terrence Bradley. So, I mean, that's fine. Throw out his testimony. But what about her friend? She also had a friend who testified and had no reason to lie, and she told the truth on the stand, and she should be rewarded for that. His inconsistencies, demeanor, and generally non-responsive answers left far too brittle a foundation upon which to build any conclusions. While prior inconsistent statements can be considered as substantive evidence under Georgia law, Bradley's impeachment by text messages did not establish the basis for which he claimed such sweeping knowledge of Wade's personal affairs. In addition, while the testimony of Robin Yeardy, that's her name, Robin Yeardy, raised doubts about the state's assertions, it ultimately lacked context and detail. How? How did it lack context and detail? They literally asked her, from your understanding, did this romantic relationship start before he was hired? She said yes. And from her understanding, it started in 2019. So I don't see how it lacked context and detail. Her testimony was very clear and detailed, in my opinion. Even after considering the proffered cell phone testimony from defendant Trump, along with the entirety of the other evidence, neither side was able to conclusively establish by a preponderance of the evidence when the relationship evolved into a romantic one. However, an odor of mendacity remains. So an odor of untruthfulness is what the word mendacity means. The court is not under an obligation to ferret out every instance of potential dishonesty from each witness or defendant ever presented in open court. Such an expectation would mean an end to the efficient disposition of criminal and civil proceedings. Yet reasonable questions about whether the district attorney and her hand-selected lead SADA testified untruthfully about the timing of their relationship further underpin the finding of an appearance of impropriety and the need to make proportional efforts to cure it. So if she lied on the stand, she's out completely. So, I mean, he's saying there's a potential that they lied on the stand together and they're not being truthful about this relationship. It's so crazy. Ultimately, dismissal of the indictment is not the appropriate remedy to adequately dissipate the financial cloud of impropriety and potential untruthfulness found here. There has not been a showing that the defendant's due process rights have been violated or that the issue involved prejudices the defendants in any way. How has the defendant's rights not been violated if they are in cahoots romantically and professionally so that they both benefit financially from this case and politically? It's literally a layup. It's a freaking layup. Nor is disqualification of a constitutional officer necessary when a less dramatic and sufficiently remedial option is available. The court therefore concludes that the prosecution of this case cannot proceed until the state selects one of the two options. The district attorney may choose to step aside along with the whole of her office and refer the prosecution to the prosecuting attorney's counsel for reassignment. Alternatively, SADA Wade can withdraw, allowing the district attorney, the defendants, and the public to move forward without his presence or remuneration, distracting from and potentially compromising the merits of this case. Forensic misconduct. The Georgia Supreme Court also recognizes forensic misconduct or improper comment by the state as grounds for disqualification. One example of such forensic misconduct is expression by the prosecuting attorney of his belief in the defendant's guilt, Williams versus State. Okay, let's keep going. As guidance, Williams instructs that the trial court should take into consideration whether such remarks were part of a calculated plan, evincing a design to prejudice the defendant in the minds of the jurors, or whether such remarks were inadvertent utterances. Okay, let's keep going. The court has not located nor been provided with a single additional case exploring the relevant standard for forensic misconduct or an opinion that actually resulted in disqualification under Georgia law. Left unexplored, therefore, is how other examples of forensic misconduct can manifest, such as whether statements that stop short of commenting on the guilt of a defendant can be disqualifying, nor has it been decided if some showing of prejudice is required, and how a trial court should go about determining whether such prejudice exists, nor is it clear whether the analysis differs depending on the pretrial posture of the case. Unmoored from precedent, the court feels confined to the boundaries of Williams and restricts the application of the facts found here to its limited holding. The defendants have exhaustively documented every public comment made by the district attorney concerning this case through their motion and supplemental filings. Many of these have already been addressed through a pretrial challenge made on similar grounds brought by defendants Trump and Latham. This court incorporates and adopts the sound reasoning of Judge McBurney and finds that any comments made by the district attorney prior to July 31st, 2023 did not amount to disqualifying forensic misconduct. Similarly, more recent comments describing the charges in the indictment, the procedural posture of this case, the office's conviction rates, and personal behind-the-scenes anecdotes are not disqualifying. This includes the district attorney's unorthodox decision to make on-the-record comments and authorize members of her staff to do likewise. To authors intent on publishing a book about the special grand jury's investigation during the pendency of this case, such decisions may have ancillary prejudicial efforts yet to be realized, but the comments do not rise to the level of disqualification under Williams. So she talking about the case, trying to write a book on the fucking jurors and shit. I mean, it's crazy. The same cannot so easily be said of the district attorney's prepared speech deliverance before the congregation of a local Atlanta church on January 14, 2024. In these public and televised comments, the district attorney complained that a Fulton County commissioner and so many others questioned her decision to hire SADA Wade. When referring to her detractors throughout the speech, she frequently utilized the plural they. The state argues the speech was not aimed at any of the defendants in this case. Maybe so, but maybe not. Therein lies the danger of public comment by a prosecuting attorney. By including a reference to so many others on the heels of defendant Roman's motion, which instigated the entire controversy, the district attorney left that question open for the public to consider. The court finds, after considering the statement as a whole under all the circumstances surrounding its issuance, that the district attorney's speech did include defendant Roman and his counsel within its ambit, whether intentional or not, which, I mean, is grounds for dismissal as well. It's so freaking, like, these people get so many passes. He's literally saying they did something wrong. She did something wrong here. It looks like she could be lying here. It looks like she had no evidence on if she paid Nathan Wade back here. She made the church speech, which was highly, galvanizing, if you will, especially for a jury. And all these things adding up, and he still makes the decision to allow her to continue the case. Fascinating. More at issue. Instead of attributing to criticism to a criminal accused general aversion to being convicted and facing a prison sentence, the district attorney ascribed the effort as motivated by playing the race card. She went on to frequently refer to SADA Wade as the black man, while her other unchallenged SADAs were labeled one white woman and one white man. The effects of this speech was to cast racial aspersion at an indicted defendant's decision to file this pretrial motion. However, the speech did not specifically mention any defendant by name, although not improvised or inadvertent. It also did not address the merits of the indicted offenses in an effort to move the trial itself to the court of public opinion, nor did it disclose sensitive or confidential evidence yet to be revealed or admitted at trial. In addition, the case is too far removed from jury selection to establish a permanent taint of the jury pool. As best it can divine, under the sole direction of Williams, the court cannot find that this speech crossed the line to the point where the defendants have been denied the opportunity for a fundamentally fair trial, or that it requires the district attorney's disqualification. But it was also still legally improper. Providing this type of public comment creates dangerous waters for the district attorney to wade further into. And he says wade waters further into, no pun intended, because Nathan Wade got further into her and drowned in her waters, obviously. But anyways, my point is, in this case, with the church speech and potentially tainting a jury pool, he should have issued a gag order. She should not be able to speak publicly about this case anymore, especially with the appearance of impropriety that she's under and she's about to be even more heavily scrutinized. It just doesn't make sense. The time may well have arrived for an order preventing the state from mentioning the case in any public forum to prevent prejudicial pretrial publicity, but that is not the motion presently before the court. So the defendant needs to push for a motion, a gag order or something. The defendant's motions demanding disqualification and dismissal based on forensic misconduct are denied. So there you have it. Other grounds. The defendants invoke a range of other constitutional, statutory, and county provisions in support of disqualification, including Georgia Construct, Article 1, and all this other type of shit. All right, they're citing case law again. This statute does not place limitations on the appointment of a SADA to work on a specific case as opposed to county approval of a general employee. While SADA Wade's contract did not limit his work to any particular case, the testimony established as much, and the defendants have not produced any evidence demonstrating that his work ever expanded beyond his prosecution. Further, to the extent the defendants argue the circumstances of Wade's loyalty oath create independent grounds for disqualification, the court incorporates its previous order on the subject and denies the motion. As for the remaining provisions and arguments, the court has not been presented with any authority that such violations, even if proven, amount to an actual conflict of interest, nor that an appearance of impropriety can apply to any instances of inappropriate or wrongful behavior. In each case applying the appearance standard, the impropriety was connected in some way to an allegation of a potential and previously recognized actual conflict. In a separate motion adopting the arguments of her co-defendants, Defendant Latham presents an additional theory. She asserts the right to call the district attorney as a witness at trial to examine her biases toward the defendants and demonstrate that she brought a politically motivated prosecution. Accepting this sole citation raised in support, Duncan versus State, where they're citing more case law. Okay. Duncan versus State. All right. Requires ignorance of the opinions surrounding context. Actually reading the case and the authority upon which it relies, and not simply quoting a head note, reveals that the Court of Appeals' antiquated use of the word prosecutor referred not to the legal officer handling the criminal case on behalf of the public, but rather the main witness for the state. Defendant Latham asserts a claim accurately categorized as one of selective prosecution, and the United States Supreme Court has recognized that such claims are not a defense on the merits of any criminal charges themselves. Instead, a claim of selective prosecution must be brought in the form of a motion asking the trial court to exercise its judicial power to equal protection grounds. Lacking such a showing here, or any foundation in law or the rules of evidence, this motion is denied. Conclusion: whether this case ends in convictions, acquittals, or something in between, the result should be one that instills confidence in the process. A reasonable observer, unburdened by partisan blinders, should believe the law was impartially applied, that those accused of crimes had a fair opportunity to present their defenses, and that any verdict was based on our criminal justice system's best efforts at ascertaining the truth. Any distractions that detract from these goals, if remedial under the law, should be proportionally addressed. After consideration of the record established on these motions, the court finds the allegations and evidence legally insufficient to support a finding of an actual conflict of interest. However, the appearance of impropriety remains and must be handled as previously outlined before the prosecution can proceed. The defendant's motion are therefore granted in part and denied in part. So ordered this 15th day of March 2024. Judge Scott McAfee. So there you have it. The full ruling. I mean, it's very disappointing to see all this evidence, all this cloud on this case when it comes to just the fitness of Fanni Willis to proceed in this prosecution. It just doesn't make sense. I believe she's dead wrong. I believe she lied on the stand. I believe she lied under oath. I believe her and Nathan Wade perjured themselves. So did Terrence Bradley, in my opinion. I think they all should be disbarred. I think they're in cahoots. I think that Fanni Willis and Nathan Wade tampered with the witness, Terrence Bradley. I think Fanni Willis potentially could have also tried to tamper with the other witness. I forgot her name, the woman who was her best friend. But this is the two-tier justice system that we have, you know, and y'all know my stance. I don't believe that these types of women are fit to lead, and they continue to get a slap on the wrist. They continue to work around the law, and they're able to stay in positions of power because of their ethnicity, what they look like. So, even if they're doing a bad job, they're still able to continue to stay and do their job. And I just think that's so wrong. I think it's so wrong. And I think we're making a huge mistake. This is a historical ruling and it's the wrong one. But I appreciate everybody who joined. I just wanted to break that down really quickly. And, you know, just to give you guys my thoughts, y'all know we're very disappointed over here because we support President Donald Trump. And we support the law and how it is supposed to be interpreted, not how these leftist liberal kook judges are interpreting the law in this day and age. Shout out to IRS with the $3 super trap. He's definitely outside with it.
Hold on. Hello? Where we at? Oh, you want to know where I'm at? We outside!
So y'all already know what it is, man. Support the stream. Y'all know I'm being shadow banned and significantly accosted on this YouTube channel here. So help me out, help a brother out. We're trying our best to get the message out there. But the only way to solve this issue, I guess, is to go out and vote on election day. That's the only option that we have. And it's unfortunate, but you know, it has to be too big to rig. Just like, you know, Trump said, too big to rig, hashtag too big to rig. We have to beat the Democrats in a landslide come election day. And it's got to be huge. It's got to be enormous. It's got to be gigantic. It's got to be ginormous. But anyways, you already know what it is. It's your boy, the Black Gen Z Mindset, a.k.a. BGZM News 17, a.k.a. Jinquavius Jackson. And we are going to go ahead and send it off to Jinquavius Jackson to take us away. Guys, hit the Super Chat, hit the Cash App, hit the PayPal, support the channel, sign up to the Patreon if you so choose, and buy the merch. We got some beautiful merch. We have great Trumps of Blood t-shirts still available now. So make sure you go get that. Make sure you go cop that and support the channel in any way possible. But until next time, guys, you already know I got a premiere coming at 7:30. So be on the lookout for that one. That one is going to be huge. So just make sure you're paying attention. Peace.
What's good, Shadow Realm? It's your boy Quavius Jackson, and y'all already know I'm demonetized and shadow banned in this bitch. So if you want to contribute, go to the Cash App, the PayPal, the GoFundMe, or join the Patreon. Also, don't forget to visit the merch store for all your favorite BGZM News 17 gear, including our exclusive Trump is a Blood t-shirt. Go fast before they sell out. They are already flying off the shelves, no cap. And remember, these super gremlins are on demon time.
I'm here on the corner of MLK and Medgar Evers, and it's a very tranquil scene compared to just a couple hours ago where a drive-by shooting just took place. Excuse me, I'm getting live updates as we speak. I've just been updated to the amount of casualties from this drive-by shooting, and I'm getting reports that 2 people were actually declared deceased and 27 others were shot and injured but are in stable condition. And although we must pray for the families of the fallen, we must also praise God for the aim of the super gremlin. If you want to know more about the victims of this crime, make sure you add BGZM News 17 on Patreon at www.patreon.com/blackgenzmindset. Also, don't forget to like the video, share the video, subscribe to the YouTube channel, and comment on the video to continue the discussion on how we can find solutions to all this gun violence in the streets. For more hard-hitting news coverage from the community, by the community, I'm Quavius Jackson, here live, reporting from Atlanta, Georgia, BGZM News 17.
And cut.
All right, dog. Let's get the out of here before these niggas come back.
Whoa. Yo.
Whoa.
Ain't that nigga Jay
Nah,
Quavius?
that ain't me, that ain't me.
He just went live
That
with
ain't
that
me.
funky ass suit
That's
on.
that nigga. That's not me.
Hey, get that nigga.
Jay Quavius
jump
Jackson,
on that
here
nigga,
live,
man.
reporting from Atlanta, Georgia. Pray for me.
Gang violence and other kind of violence.
Get away! I could be at work, at school, in my car, I can still get shot by the police. But I can get shot anywhere.
So it is what it is.